Not many people know this, but an X-rated Mickey Mouse comic from the 70s is directly responsible for our free speech right to parody and satire. So there's a cartoonist named Dan O'Neill who throughout the 1960s had a political comic strip in the San Francisco Chronicle called Odd Bodkins. And despite its massive popularity at the time, the San Francisco Chronicle always wanted to get rid of it because of how controversial it was. He knew that if he did ever get fired or quit, he would lose ownership of Odd Bodkins. So he hatched a scheme. He started adding Disney characters to his comic strip because he figured that if he ever got fired, the Chronicle would be more likely to give the rights to the book to him out of fear of getting sued by Disney. And O'Neill eventually was fired by the Chronicle, and they did eventually give the rights of Odd Bodkins to him. So his plan worked, but it also got him thinking. Why are people scared of getting sued by Disney anyway? And so he hatched another plan. He got a group of artists together and they started making X-rated Disney comics with characters like Mickey Mouse and Minnie Mouse doing very explicit things. And his goal was to get sued by Disney so that he could go to court and fight for people's rights to parody and satire massive characters from big corporations. You see, at the time, things like fair use and parody and satire were not actually protected by law. They were common law, which means that certain judges had ruled in favor of things like fair use and parody. And so judges could look back at this legal precedent and choose to side with fair use and parody. In 1971, Dan O'Neill and the rest of the Air Pirates were sued by Disney. And over the next several years, they went to court multiple times fighting against Disney for their right to be able to parody these characters. But the courts were not siding with the Air Pirates. The court had ruled that Dan O'Neill and the rest of the Air Pirates were legally not allowed to draw Disney characters in their comics. But Dan O'Neill was not done. He knew that if he could somehow get the case brought to a federal level and bring it into criminal court, he could make the case about free speech rather than copyright infringement. And the public would quickly turn against Disney for essentially trying to put a guy in prison for drawing comics. So in 1979, he purposely violated the court ruling to stop drawing Disney characters by putting out a comic called Communique #1 from the Mouse Liberation Front, which was a comic about Mickey and Minnie and other Disney characters explaining the details of the court case that he was having. Criminal charges were filed against Dan O'Neill, and his case was brought to the Supreme Court where he was facing prison time. At the Supreme Court, Dan O'Neill hit hard at making this a case about free speech and parody and fair use. And ultimately in 1980, Dan O'Neill did not win the case, but he received no jail time, did not have to admit any kind of guilt over any of the charges, and did not have to pay any fees. Most importantly, largely because of the increased public awareness that Dan O'Neill brought to this issue, the Copyright Act of 1976 was passed, which actually codified fair use, parody, and satire into law so that people were actually protected at a federal level.